5 seconds to go. Start. It is regrettable that some anomalies have appeared because of insufficient recruitment of direct recruits in the past in this particular service, but that, in our opinion, can be no reason for striking down the seniority list prepared in 1963, which is undoubtedly in strict accordance with the rotational system based on the fixed quotas for recruitment of direct recruits and promotees. The order of the board of 1963, on the basis of which the impugned seniority list of appraisers has been prepared, clearly lays down that the principle of determination of seniority of the direct recruits and the promotees inter se in the prescribed ratio of 1:1 should be worked out. This order is in accordance with the circular of 1959, and as we have said already, there is no inherent vice in the principle of fixing seniority by rotation in a case where a service is composed in fixed proportion of direct recruits and promotees. The argument made before us is that the decision will have to be ignored on the ground that it is per incurium, as the attention of the bench which decided the case was not invited to the binding decisions of the Constitution bench and a coordinate bench. Prima facie, we find substance in the argument that the attention of the bench which decided the case of K. Meghachandra was not invited to the aforesaid binding precedents. Therefore, we are of the view that the appropriate course of action will be to refer the question to a larger bench. We are dealing with a case where the rotation of quota or rota and quota system is being followed. If the promotees are recruited in the relevant recruitment year, but the process of recruitment of the direct recruits which commenced in the same recruitment year could not be completed in the same year, the direct recruits appointed subsequently will have to be interspaced between the promotees of the same recruitment year. In such a case, it cannot be said that direct recruits were not available during the recruitment year. Their appointment could not be made during the same year, though the process of appointment commenced in the same year. But if the process of recruitment of the direct recruits is completed in the same recruitment year, but an adequate number of candidates could not be selected, the shortfall should be carried forward to the next recruitment year. In such cases, the candidates who are selected against shortfall vacancies will have to be bunched below the promotees of the earlier years. Unless such a procedure is followed, the rotation of quota system will be defeated. Coming to the facts of the case, though process of recruitment of direct recruits to the post of income tax inspectors commenced in the recruitment year 2009-10, the same could not be completed in the same recruitment year. This is not a case where an adequate number of direct recruits could not be recruited even though the recruitment was done in the recruitment year itself. In this case, those who were eligible for direct recruitment were deprived of the opportunity, as the process of recruitment could not be completed during the same recruitment year 2009-10 due to no fault on their part. The documents annexed to the counter affidavit show that the segregation of vacancies for 2009-10 and 2010-11 has been properly made. In any event, the decision in the case of K. Meghachandra has a prospective operation. The seniority list of 7 September 2016 was made in terms of the decision in the case of N.R. Parmar. Hence, the same could not have been altered on 13th February 2018 when the said decision was in force. Thus, our conclusion can be summarized as under. The decision in the case of K. Meghachandra requires reconsideration by a larger bench in view of the fact that the binding decision of a constitution bench and another binding decision of a coordinate bench in the case of M. Subba Reddy were not placed for consideration before the bench which decided the case of K. Meghachandra. Even assuming that the case of K. Meghachandra was correctly decided, paragraph 39 of the decision shows that the decision in the case of N.R. Parmar has been prospectively overruled by observing that the decision will not affect the inter se seniority already fixed on the basis of the case of N.R. Parmar, and the same was protected. It is also held that the decision will apply prospectively except where seniority is to be fixed under the relevant rules from the date of vacancy, the date of advertisement. In this case, as on the date when the case of N.R. Parmar was decided, there was no rule which required that the inter se seniority of direct recruits and promotees to the post of income tax inspectors should be fixed from the date on which a person is born in the cadre. In the facts of the case, the seniority list was correctly published on 7 September 2016 in terms of the decision in the case of N.R. Parmar by interspacing those direct recruits who were eligible in the recruitment year 2009-10 and were appointed against the vacancies of the said year, with 53 promotees who were promoted by DPC dated 29th June 2009. Stop.